What if your employer told you your annual salary already includes everything? Overtime, weekends, public holidays, but the law stated otherwise. That's exactly what Australia's biggest supermarkets told thousands of their managers. In 2025, the Fair Work Ombudsman took on Woolworths and Coles, two retail giants accused of massive underpayments. And the federal court's decision caused the two companies to pay an estimate of over $1 billion, despite 307 million remediation payments had already been made by those companies. Check what happened with Woolworths' stock price. Today, we will unpack this landmark case and explore how Australia's employment law works, what legal battles led to this moment, the three big issues at stake, and finally, what it all means for Australian businesses and workers. Australia's employment law rests on three key pillars: the Fair Work Act, the Modern Awards, and employment contracts. The Fair Work Act is the foundation. It sets out the national employment standards, things like working hours, leave, and minimum entitlements. It provides the safety net to most employees in private sectors. Then come the Modern Awards, such as the General Retail Industry Award. These are legally binding instruments that set minimum wages and conditions for specific industries. Finally, between the employer and employee, there is employment contract, which can add benefits but never remove award or statutory entitlements. It is the triangular structure that underpins the protective mechanism of Australia's labour laws. Between 2015 and 2020, thousands of salary store and department managers at Woolworths and Coles were allegedly underpaid compared to what they should have received at the General Retail Industry Award. This judgment combined four different proceedings, two by the Fair Work Ombudsman and two class actions by employees. To make sense of this 195 pages judgment dealing with a combined 129 issues categorized into three tiers by Justice Perram, I would like to focus on the three key aspects. Firstly, whether all-inclusive fixed salary package is a solution to resolve all employment disputes. In particular, can employer lawfully set off salaries paid against award entitlements? Secondly, what happened if you were required to work overtime, but the employer didn't keep the records? What if an employee has to work outside their rostered hours, which was not authorized by the employer? Thirdly, how is compensation for underpayment really calculated? First, let's look at the history and legal battles led to this moment. Before this case, courts had grappled with similar questions. In Politi and Echob, the court first accepted that overpayments could set off underpayments, but only where those payments related to the same type of entitlement. Fast forward to Watman and Macquarie Bank. In that decision, the related award provides that an employee will receive a 17.5% annual leave loading or weekend penalty rates, whichever was greater. Such amount was not paid by Macquarie Bank. The bank then said it paid to commissions on top of the employee's base salary, so such part of commissions should be used to set off the unpaid loadings or penalty rates. The court sided with the bank, but noted that employers must show that any higher payments were intended to cover specific award entitlements. Now let's switch to the reasoning of this case. The first major issue goes to the heart of the wage debate. Can an employer set off an employee's fixed salary against award entitlements like overtime or penalties? In Part A of the judgment, Justice Perram dissected clauses like Woolworths' minimum entitlements term. As a matter of background, all of Woolworths' salaried employees were given annual salaries. These salaries were provided by a template letter of offer and employment contract. The salaries consist of a base salary, a car allowance, and superannuation. These three annual amounts were collectively referred to in the contract as the remuneration. Under the contract, Woolworths opted for a fortnightly rather than weekly payment cadence. Justice Perram said this: as we will be seeing, this is conceptually significant. In particular, there was no obligation to pay the annual remuneration, but rather only an obligation to pay 1/26 of the annual remuneration each fortnight. Why is this important? Well, it's because Woolworths argued that this fortnightly payment was more than the minimum wage. If the employees said they were underpaid under the award, then what had been overpaid under the contract should then be used to set off the unpaid amount. And the terms of Woolworths contract supports this argument. This literally means that as long as Woolworths or Coles paid an annual salary which is fortnight rate times 26, and such rate is higher than the minimum entitlements, Woolworths or Coles are discharged to pay anything else, and any surplus paid could be used to set off any additional entitlements, including overtime, loadings, and allowances under the award. Woolworths also made a very convincing point. They cannot possibly know in advance the entitlement to overtime to accrue. Since that cannot be known, it cannot be the case that award entitlements must be paid in a particular pay period. That's why they have this clause in the first place, to give a pool of surplus that could cover any future unpredictable shortfall. Like what the court said, its evident intent is to permit Woolworths to pool its excess award payments over a period of 6 months, and then to deem that pool is to be satisfied its obligation to make payments under the award. Now let's look at Fair Work Ombudsman's arguments. Firstly, it says that such clause in an employment contract is not capable of any lawful operation because of 2 reasons. Firstly, Section 323 of the Fair Work Act prescribes the method and frequency of payment, and it says that an employer must pay in full all relevant entitlements at least monthly. Secondly, Section 324 of the Fair Work Act prescribes that if an employer wishes to deduct an amount paid, it must be authorized by the employee in writing or by relevant regulator. So what does the court say? The short version is that the court disagreed with the Woolworths and Coles and considered the employees must be paid in full for each pay period. An employer can't fix an underpayment from one pay period by overpaying in another. This means a payment in one fortnight cannot lawfully compensate for an underpayment in another. This ruling wiped out the idea of 6 months averaging. Instead, set-offs can only occur within the same pay period. But the court also acknowledges that whether the current law, being Section 323, prevents attribution of over-award payments across pay period is a difficult question, and it is not a straightforward question. Woolworths has 2 sets of payment obligations. The first consists of its obligation to pay a fortnightly installment of the annual remuneration. The second consists of its obligations to pay amounts due under the award each fortnight. As a matter of contract law, the court notes that there is no issue for Woolworths or Coles to use an attribution clause for the set-off purpose. At common law, nothing prevents a creditor and a debtor from agreeing that the payment of a smaller debt will also discharge a larger debt. However, the position is more complex in an employment context, regulated under the Fair Work Act and the award. This is because the payment and the contractual provision which purported to discharge the employer's obligation to pay an employee's entitlements could be less than award entitlements. The court then concludes that the set-off clause must be read so that it only applies within a fortnightly pay period, not a period of 26 weeks. The second big issue dealt with one of the most overlooked legal duties, keeping records. The Fair Work Act requires employers to keep certain records relating to their employees. Both Woolworths and Coles had incomplete data, with years of missing timesheets and inconsistent clocking records. Section 535 subsection 1 of the Fair Work Act requires an employer to make and keep for 7 years employee records of the kind prescribed by the Fair Work Regulation 2009. There are 3 relevant record-keeping obligations. Firstly, accessibility requirement. Basically, the regulation requires the record to be in a form that is readily accessible to an inspector. Secondly, higher rates of payment requirement. Regulation requires there to be a record setting out any incentive-based payment, bonus, loading, penalty rate, or other monetary allowance an employee is entitled to be paid. Thirdly, overtime hours actually worked requirement. Regulation requires that if a penalty rate or loading must be paid for overtime hours actually worked, the employer must make and keep a record that specifies either the number of overtime hours worked by the employee during each day or when the employee started and finished working overtime hours. Now let's look at Woolworths and Coles arguments. Firstly, they argue they have all-inclusive arrangement for the annual salaries paid to the employees. And secondly, they cannot be assumed that loadings and penalty rates are payable in the first instance. If those rates are not payable, then no recording is required. The Fair Work Ombudsman argues that Woolworths and Coles have contravened the requirement of records keeping and seeks the imposition of a civil penalty. The Fair Work Ombudsman also argued that without those records, workers' claims should be presumed correct. The court says the record must have the required details, and the form of the payment, such as it being all-inclusive, does not alter that requirement. Under Section 557C of the Fair Work Act, if an employer fails to keep proper time and pay records, the burden of proof reverses. That means the employer must disprove underpayment allegations. It is common that in court disputes, the employee and the employer could not agree with each other on the starting and finishing time of certain shifts, and the employer now needs to prove the employee is wrong. If records are inadequate, courts will infer in favor of employees. This ensures employers can't benefit from their own poor compliance system. When you don't track the hours your staff actually work, the law assumes they worked every hour they claim. So record keeping isn't just admin, it's legal protection. The third issue was about compensation, or how to calculate the underpayment. Once the court ruled the set-off clause is invalid beyond each pay period, Woolworths tried another argument. Even if it technically underpaid workers in some fortnights, those employees earned more overall in the year. So they said, shouldn't that reduce compensation? The court said no. Justice Perram illustrated this with an example. If an employee was paid $2,000 per fortnight, while their award wage was $1,800, and later the worked overtime was $500 without pay, the company still earned that $500. Even if they'd been overpaid earlier, that overpayment can't cancel the underpayment. The employee is to be restored to the position he or she would have been if the contraventions have not occurred. The logic is simple. Each pay period stands alone. An employer can't use past overpayments to erase later breaches of minimum pay entitlements. On a side note, Woolworths even submits that they could set off the bonus paid under the incentive scheme to its employees. The court considers the bonus to be a separate contractual arrangement with the employees and was in addition to the remuneration, so justice doesn't work like accounting. So what we can learn from this case? There are some interesting facts and takeaway points, regardless of whether you are employer or employee. Number one, many people don't have a written contract. That's why the parties spend considerable time arguing about the implied obligations under the oral contract and the retail award. Despite oral contract still counts, it would save much time and avoid uncertainty if there is a written contract in place. Number two, a properly drafted annualized salary arrangement can still be effective to allow set-off over the course of the year. This has been well established in the case re-annualized wage arrangements. The failure of Woolworths and Coles in this case is that the set-off clause is too wide and falls short to identify any specific payment to discharge their work payment obligations. My thinking is that many employers may start thinking of redrafting their employment agreements so that any set of provisions would detail the specific entitlements to be set off periodically. Number three, the set-off clause is generally effective, but its operation is limited. Difficulty in predicting or identifying when particular entitlements accrue is not an excuse. Bonus and commissions calculated under separate contractual arrangements normally would not count as set-off amount for underpayment. They are considered as payment in addition to the remuneration, like in this case. Employers need better terms if they intend to use them as a set-off. Number four, more employers, in particular supermarket businesses, will be encouraged to use a clock-in, clock-out system to record employees' hours of work to satisfy the requirement to make records of overtime hours. It is now proven that a mere directions to clock in and clock out is not capable of satisfying these requirements, so employers need a better system. Number five, practically, how are people going to deal with overtime requests when there is emergency? The law is clear. Variations to a roster need not be in writing. It can be an oral direction, but variations to a regular pattern of work must be in writing. Number six, If you are a part-time employee in retail industry, or you are a business owner that hires lots of part-time employees, you need to understand the definition under clause 12 of the award. A part-time employee is an employee who works less than 38 ordinary hours per week, but nevertheless still has reasonably predictable hours of work. When a part-time employee works in excess of the ordinary hours agreed, there is no dispute that the employee is entitled to overtime payment. That's how many part-time Woolworths and Coles workers get paid in this case. Number 7. Checklist for employees tick and agree that they will not work overtime without employer's consent may not be enough. If the employee is not aware of the circumstances, it will not count. Now let's conclude this video. The judgment will certainly cause significant and widespread changes to retail practice. It sends a crystal clear message. Firstly, sets-off must match each pay period. Secondly, records must be complete and accurate. And lastly, compensation is calculated by what was earned, not by hindsight averages. For Australian employers, that means auditing contracts, rewriting salary clauses, and tightening compliance systems. For employees, it means stronger protection and more leverage when pay doesn't match the law. Ultimately, this case redefines how fairness is measured in salaried work, because fair pay isn't about averages, it's about accountability, period by period.